Good morning, or afternoon, I guess, as the case may be. This is Mark Gaylord from Ballard Spahr. This is the time and place we had set up for a webinar entitled Lions and Tigers and Bond Defaults, How Towns, Cities, Special Service Districts Can Survive the Great Recession. I want to welcome those who have joined us today. We have a panel of 4 lawyers here that want to take time and talk about these issues that are very prevalent in many states. I'm here in the Salt Lake City office, which have been working these types of matters. We also have as panelists Vince Marriott, who is in our Philadelphia office, heads up our bankruptcy department. In addition to that is Joe Fanone, who is in the public finance in the D.C. office. And then Jeff Cohen, who is in our Denver office and has a wealth of experience dealing with a number of the special service district issues on a regular basis. So I'd like to do, and what we plan to do today is, this is kind of just an open discussion between the 4 of us on a variety of issues. One of the reasons we're here is because defaults and bankruptcies of cities, towns, and special improvement districts in the past have been a fairly rare occurrence, but that's no longer the case. It is special improvement district whose bonds, often called dirt bonds, that are grabbing headlines. And as well as many of the large cities, we all heard that Stockton, California, the largest city to file bankruptcy recently, is there. So what we're going to do is kind of address issues that face cities and towns, and particularly special improvement districts, in terms of the current marketplace. In doing that, I'd like to address what we plan to do is kind of deal with it in 3 or 4 stages. First, we'll address the origination and the structure of the dirt bonds. Second, we'll address the defaults and workouts of the special improvement districts. Third, we'll address the bankruptcy considerations, and then we'll follow it up with Create Solutions. This is a webinar. We'd love to take your questions, but it's up for us to do so. So we're just going to jump in and kind of talk about these and go from there. What is a special service district? A special improvement district is a geographic area that's within a county or a municipality in which the city ordinarily constructs public improvements and assesses lien against them. There are benefits that are the benefits that are conferred are usually conferred only upon taxpayers within that assessment area. They are generally creatures of state and local ordinance, which the districts oftentimes vary from state to state. Might be able to elaborate a little bit about what is the real difference between a SID and other types of indoor areas that are important to this area.
I think one of the things that we'll talk about as it becomes relevant to the discussion, but from a broader view, bonds issued by these districts have some of these surface attributes of what people, or what I would describe as regular garden variety municipal debt. But there are very real differences with these sorts of bonds from the perspective of bondholders than is true of normal municipal debt. And go through this, and as we talk about some of these differences, they will become more important as we get into the workout and bankruptcy discussion, because the differences between these types of bonds and municipal bonds become most pronounced in workout, enforcement, and bankruptcy context. So raise these issues and point out these differences as we go forward and as they relevant to the discussion.
Vince, to that, just as from an investor's perspective, or from the fund's perspective, or a perspective, in looking at a special improvement bond, what's very important to keep in mind is that the tax base that provides the fund for repayment of that debt obligation is created by the proceeds of the bond itself. It's not pre-existing most often. So, 95% of the time. So that what's very important is to make sure in evaluating what you hold or what you want to buy or what you want to sell is whether the proceeds of that debt related into the project and whether in fact that project is completed and operating. Remember that these special improvement district bonds are just a fancy or not fancy way of providing non-recourse financing or non-recourse construction financing. As we all know, construction loans are inherently very risky obligations that are usually mature and balloon in 1 year or less. These bonds, though, don't. So obviously, they persist over some serious amount of time and have a large return. Remember that the source of repayment is the investment of the proceeds of the debt. So that taking a look at the project and its state and whether it's operating or not is really the key economic analysis.
If that's an important point to make at the beginning, as the first slide or the slide here indicates, one of the primary sources used by counties and municipalities to finance the infrastructure, and this is by the districts or the counties, is interim warrants and anticipation bonds, which oftentimes will precede an assessment bond that's issued once the assessment lien is imposed. Jeff, you also mentioned the idea that there might be revenue bonds, which is not listed here. What aspect does that add to the equation?
It's a different animal because in the assessment lien area, you've got lien only on pledged revenues, as in the collections that the district makes underlying tax base, assuming the proceeds went into that tax base. The revenue bonds get paid out of user fees, if you will, from the project and built, and you have, for instance, oftentimes a pre-existing regulation or essential service that's being provided to the population. So you have a great likelihood that proceeds of the revenue bond are going to be used to build the improvements that is being contemplated. And bankruptcy code gives special protection to revenue bond holders versus special improvement bond holders. They're slightly different animals. Of course, the bonds are much more speculative than the revenue bonds, because again, revenue bonds used to fund projects, usually for essential services like water, sewer, hospitals, airports, those sorts of things, for where the user pre-existing that would pay a fee for the service that is being constructed, whereas the special improvement bond, it's really a gleam in the eye of the developer from day one.
And as we'll talk a little bit more, I mean, when we throw out interim warrants and anticipation bonds, ordinarily those are done and issued as a way for counties, municipalities, and districts to construct the infrastructure before the assessment lien is actually assessed, whereas assessment bonds often will take out the warrants and anticipation bonds and become the vehicle through which the county covers the costs in the long-term future with a long-term payout. The thing about special improvement districts that's important to remember is they're generally formed by counties, cities, and towns. Either whether it's city council or a county council, they're often done at the request and in cooperation with property owners and developers. In fact, most districts require the property owner's consent. The cities are not necessarily, depending on state law, separate political subdivisions. They may have no independent existence, but Jeff, why don't you or Joe address that issue?
Yeah, in terms of when you characterize it as perhaps not having an independent existence, I think it's clearly a separate legal entity. The issue regarding independence may be more of a control issue if created by a city or a municipality, and it's appointing board members to the separate improvement district board or community development authority, as they're referred to in Virginia. I think that's the distinction.
Well, and the distinction, I guess, is driven by the fact that in some instances, here in Utah, for example, the county ultimately is the governing board of the district, and what we face on a regular basis is the district getting sued separate and apart from the county, and what is the impact of that. And the other thing, Jeff, if you could address, the independence and what impact that might have on credit ratings and such.
Yeah, well, first let me address, in both Florida and Colorado, the districts are created by a developer when you're talking about a special improvement district, or in Florida, the community development districts. And oftentimes you have developer-controlled boards, sort of like a homeowners association, if you will. Then later on, the board elected, and of course, if the development is not going very well, then the developer still is on the board and controls the districts. Now, getting credit rating issue, interesting. I was involved to a large degree in the Jefferson County, Alabama situation, and of course, what Jefferson County filed, one of the big issues there was, well, if you filed for the county and not a special district, that was the entire county being filed, because there was no special district created for the water and sewer bonds. It was truly a county obligation, a revenue obligation. But in any event, my take on it is there was a great fear that there would be a big hit to the Alabama state rating as a result of the county bankruptcy, and that the surrounding municipalities would also take a significant hit. That's just not necessarily true. Certainly, if you have not formed a special district and it's the county that's issuing the debt, the county itself would have to file and/or suffer from the default or credit downgrade. Of course, that's one of the benefits of creating a special district in the first place, that for water and sewer as a revenue bond, or a special improvement district as assessment bonds that we're now talking about. So that not seen in this, and same thing in Florida. You have over 1.2 billion, I think, or pretty close, in community development district bonds, of which at least 400 or 500 million are in default as we speak. Across the state, mostly confined across the state, north and west, the Fort Myers area, the I-75 corridor. But nevertheless, you don't have that much of a significant impact on the Florida credit rating. So markets are sophisticated enough to see through, the default of a district and act on the district's credit rating versus the impact of the larger political subdivisions' credit rating. But I mean, that's the Moody's or Fitch's decision. But it's shibboleth that prevents this bankruptcy filing under Chapter 9 of an entity, is going to affect the credit rating of the entire county or state, and that has not been experienced, in fact.
Another important aspect of any special improvement district, and particularly for bondholders and the like, is what's the tax-exempt status of that. Joe, can you elaborate on that for just a moment?
Sure. In order for these bonds to be tax-exempt, they can finance public infrastructure, given the fact that the Revenue Code treats special assessments as a private payment as opposed to a general applicable tax, and that is the key factor. I mean, one other thing, just kind of in general, as we're talking here, introduction of the use of the improvement districts, Clearly, an improvement district where the bonds are supported by assessments. Take our residential developments. The other utilization of assessment districts or improvement districts in connection with tax increment financing, where they will be a backup that would be laid on in that the incremental tax revenues, whether they be real property, sales tax, were not sufficient to pay debt service on the bonds issued there. And normally, these types of projects that are being developed are mixed-use developments. As a result, they obviously have significant real property tax increases, sales tax, and types of taxes. So just want to draw that general distinction as to how the improvement districts have been utilized.
And it's a good point to make in the sense that these special improvement districts, you're right, are focused on providing benefits to only those taxpayers or property owners that are within the assessment area. And they vary in terms of what this is and or improvements those include, such as sewer and water. Here in Utah, you have developers who have come to the counties and asked that they build the infrastructure to their development, but underlying development projects have to be implemented by them. They also are building large sewer treatment plants, which could have the impact of benefiting not only that particular development or those property owners that the improvements have been provided to, but that sewer water plant might provide benefits to the balance of the county. And how is that going to be properly allocated? But more importantly, to bondholders, how do they assure themselves if they do or purchase assessment bonds, how are they going to be repaid? Is it going to be from the property owners? Is it going to be from a tax revenue base or the like? And certainly, when you create these districts, there's the impact of them going beyond the borders of just the assessment area, and whether or not there's any ability for the district or the county or the municipality to impose additional obligations on those outside the assessment area. Benefits of the districts, as many on the call know, is that it promotes economic development of communities. It particularly allows growth to be paid by those who are seeking it. And as I mentioned at the beginning, creates a cooperative effort between developers, property owners, and the governing bodies in not only defining the scope and breadth of their local communities, but in assuring that there's uniformity in the way that the projects are constructed and serviced. Many of you have probably heard about the regional electrical problems in India. I think what special improvement districts do is allow for some uniformity to ensure that the services aren't interrupted on a significant basis. The considerations that we ought to consider in forming districts is that it is the control versus the liability. The districts can control the development, and then the question becomes how are those things, how is liability addressed? In addition,
can I interrupt just one couple of, because I'm looking at the screen here. And,
sure.
Yeah, I just want to say that with regard to sales tax increment financing, for instance, that would be used to, if you're building interchange off an interstate, to service a shopping center. And what happens, for instance, is a sales tax district is formed to presumably lease out the shopping center to an anchor tenant and some others. And the county would experience a sales tax increase as a result of the retail business. And then there's a devotion of the increment or the increased increment of sales tax due to the shopping center that would go to pay for the interchange on the interstate. I have two examples here in Colorado of Interstate I-25. And of course, the real shopping center doesn't get built. changes the analysis a whole lot because, again, what bondholders need to look at is what collateral they have. And often it's going to be pledged revenues in that case. And if the sales tax increment doesn't materialize, I've got the reserve fund, but that's going to be eaten up relatively quickly. And then take a look at the ratio that's done at the beginning to determine what kind of sales tax to interest payment. But we're getting some feedback from participants, so I wanted to address that the sales tax increment financing really won't change the analysis that we're giving on the SID bonds very much. However, back to the water and sewer issues, in Alabama and Jefferson County, we had a separate lien on the facility by the trustee. Oftentimes is not banned with a SID bond.
Well, Jeff, thank you. And I think when you look at the detail and you evaluate considerations in forming districts, it's important to remember that there is usually a maximum tax or there's a tax rate that is the most you can charge towards a property owner for the revenue that would be generated to pay bond, or there's a maximum assessment that's charged against each parcel of land that's affected or benefited by the assessment lien. And the property owner or the district is limited in the ability to pursue those obligors, if you will, property owners, to collect on the obligation if in fact they're in default. As you alluded earlier, it's a non-recourse obligation, and so if there's a default, you're usually only able to pursue the property that is or the properties that are affected by the district, and to be you need to consider those factors and as you move along.
Just to follow up on your initial comment, Jeff, about the allocation district or sales tax district. As a practical matter, you do not do a tax increment financing which would apply either real property taxes or sales tax for a mixed-use project unless you had a backup special assessment that would be levied in the event that the incremental tax revenues are not sufficient to debt service on the bonds. The bondholders are not prepared to take construction period risk. So all the transactions, unless you have a very mature district which is generating incremental taxes already, that type of a financing, you can't market those bonds again unless you have a cup assessment. And the reason I made the distinction between residential and mixed use is that normally a municipality is not going to be willing to pledge its incremental tax revenues, whether it be real property or sales tax, with a residential development, which it's seeing not a major economic impact on jurisdiction as a whole. It's a less likely scenario, and that's why, generally speaking, that assessment deals are really more exclusively tied to residential development.
What should bondholders focus on as we consider formation of districts? And in talking about these issues and the origination of districts, the importance of this is by the fact that with the current downturn market, what we're facing is a better understanding of the pitfalls that districts are now facing, bondholders are facing. And so when we talk about the nature of the special assessment, is the lien priorities as ad valorem taxes, which is ordinarily these types of assessment bonds are given senior priority that can leap ahead of lenders, mortgagees, and such to secure the payment, and or give them some semblance of some security, not in the formal sense, but in the sense that their obligations are going to get paid ahead of, for example, lien holders. What's the impact of that as well?
Yeah, now clearly there's been a sea change in terms of how investors are looking at these types of districts, and as you indicate, normally the special assessment statutorily is treated as being the same lien priority as ad valorem taxes as it relates to collections. But some of the issues that have been faced in situations where foreclosures have to commence, et cetera, is that normally the developed district is not the entity that's actually going to foreclose property, a tax foreclosure. It's usually the city or county that created that entity. And depending upon the statutory provisions in that jurisdiction, normally the type of covenant that you would get from a municipality or a county is that they will exercise the same rates that they normally exercise as it relates to the collection of ad valorem tax. Unfortunately, statutes give a lot of discretion to the municipality or the county in terms of when or if it commences foreclosure proceedings. So I think there's a greater emphasis now on trying to get them to contractually commit, through agreements with the trustee and with a CDA or a special improvement district, to read in a timely manner as it relates to foreclosure. The other, go ahead.
This is Ben, and this is I think an opportunity to talk about what I previewed at the beginning and how these SID bonds start to diverge in meaningful respects from traditional municipal finance. And the contrast here I'm going to draw is between fixed finance with revenue bonds, such as the Harrisburg incinerator or such as the water and sewer in Alabama, and these SID bonds. They're both issued in connection with construction of a project. For example, in the Harrisburg incinerator situation, the bondholders have neither a claim against the developer or a lien on the project, and therefore they have no enforceable rights directly against either the project, the developer. The claim, which is the special assessment claim, is held by the district, not by the bondholders. And the enforcement entity, either the bondholders or the district, but the county or the city. The bondholders are once removed holding the claim and twice removed from ability to enforce the lien. This can create meaningful impediments to the enforcement of payment of the bonds. And you've highlighted one is you're on sort of the back bench, kind of hoping the county does the right thing, and then in bankruptcy we'll see how this plays out. Potential for even more frustration.
Yeah, another area that this comes up is in connection with the allocation of a tax payment that may be made by a property owner, where you have obviously real property taxes that are due on that parcel, as well as the assessments. The assessments are the basic sole source of payment of the debt service on the bonds. But we've seen instances where the county has allowed the developer to determine if he's making a payment that's not going to be sufficient to pay both real estate taxes and assessments, allow that property owner to designate where the payment would be applied, whether it be solely applied to real estate taxes and not to assessments. And you point to the issue and try to get a sense of if these two liens are supposed to be on a parity basis, wouldn't the conclusion be that you would do a proportionate allocation if the payment is not sufficient to pay both in full. But it's really having a significant impact. Reserve funds have to be hit in the interim to pay debt service. And giving you an example, in Virginia, it's a 2-year period before you could commence foreclosure proceedings. And again, that being really the only viable remedy that's really available in these transactions, it really, it's become a significant problem. And the holders are more and more focused on trying to do everything you can contractually in the indenture and other bond documents to try to address these issues. The other that comes up is, trustees and even at the direction of holders often have no rights as it relates to the ability to stop project fund dollars going to continue to fund infrastructure improvements when the developer has failed to make assessment payments.
That raises another issue that has been propping up as well when we're trying to work out these transactions, and that's when the tax obligation becomes so delinquent, you find the county taxing authority foreclosing while concurrently you have a district or the county foreclosing on the assessment lien, or you have one or the other foreclosure, whereby if the assessment lien is in default and foreclosure is commencing immediately, the sale is occurring. So what is the impact on the tax lien? Ordinarily, at least particularly in Utah and other states nearby, the lien would remain on the property and subject to any buyer who purchased it out of the foreclosure for the assessment lien, and vice versa. If a property is going to a tax sale, it is important for both the district and the bondholders to somewhat let the property owner or the buyer of that property of a tax sale have to know the fact they're going to be subject to a substantial assessment lien if that's the case. Another issue that kind of comes out of this is the idea of whether in a particular state, I know it's different in the East as it is here compared to the West, is the ability to accelerate the assessment lien. That has both an impact from a bankruptcy, which Vince will talk about later, but also has an impact on whether or not you can close on the entire assessment lien, which may be beneficial to a bondholder, or you must foreclose on only the installments that are currently due. Going to the next issue, which is I will briefly address the creation of a district and assessment area. Again, the reason we want to address this is simply to put people on, give them some thought about what it takes to create the district, and in hindsight, looking at what we can do to improve the creation of a district and to impose an assessment area. As we all know, these are state-created, and ordinarily the governing body seeks to create the improvement district, but they are done ordinarily with the cooperation of the property owners. The reason for that is you want the property owners in the county to go hand foot together with the idea of making sure that it passes with the consent of all the property owners. If you don't have the consent of all the property owners, but you have a substantial portion of those that are going to participate, regardless, it's going to require notice to those that are affected. Any property owner may protest. Tonight, I use that any party may, because one issue that crops up in this instance is if you have lenders who have already loaned on property that's the subject of a potential newly created district, it's important that those lenders be informed of the assessment district. Joe, I think you mentioned earlier that lenders go out and actually get their approval before the assessment districts are created.
That's absolutely correct. So that I think the key thing is to anyone's ability to object to the creation of the district or claims of these, did not have proper notice and should not be subjected to the lien priority of an assessment that's been created. So we typically require that the developer get a letter from each lender acknowledging the fact that there is going to be an assessment district created, and that the lien of that special assessment, if not paid, will have priority over their mortgage, and that they potentially have could be subjected to their mortgage being wiped out in a tax sale. So we always view that as very essential.
And that's an important point, because what we're seeing, at least locally here in Utah and across the country, is efforts by even lenders who might have loaned on projects suddenly foreclose on those projects and find themselves obligated to pay these significant assessment liens that have been imposed on properties that they had thought the developer was going to develop. The problem with that is if they're not informed of the creation of the district or potentially assessment lien, what districts are facing from a litigation standpoint is these lenders walking in and claiming constitutional claims such as the lack of due process and that they weren't given notice of the creation of the assessment or the creation of the assessment lien. That can cause further delays, non-payment of the assessment liens of these new owners of property, which has a direct impact on the ability to either work out the transaction or get the monies paid. And we can address that a little bit more as we go along.
Yeah, let me go. One of the areas I've been exploring in Florida has been cooperation between the lenders, the consensual lien holders, editors, and developers to lower the assessments of the property. Because if the lenders in a default situation, they're going to usually have to write off or have severely reserved against bad debts. If they find more equity in the property, lowering the tax burden, that certainly will increase their lien value or whatever regulatory write-down the banks had to take. So there's an area of cooperation and opportunity for the consensual lien holders and the debtors or developers to work at odds against the bondholders. And of course involves all kinds of different conflicts, because oftentimes the bondholders are also the consensual lien holders.
Right.
But I just want to, people should be sensitized to that possibility.
Absolutely. And which is why the initial creation of the district is so important, because unless you have greater than 50%, you then generally won't create the district or the assessment area. But once the county has passed it or the city has passed an ordinance adopting a creation area, that will be recorded and ordinarily becomes a matter of public record, which it becomes a matter of public record, and then a developer goes out and borrows money after the fact. The district has the ability to argue that the lender was on constructive notice, even though the owner may not have informed them that the property would be subject to an assessment, was subject to an assessment area and or potential lien. The imposition or implementation options available to the district once the assessment area is created is, ordinarily the assessment area is created with the idea that you're going to construct improvements. So what does that district do in funding those costs? First of all, they have basically three ways of doing so. One, they can go out and borrow money through interim warrants and bond anticipation notes, construct the infrastructure on the front end, and then after all of the construction is done, go back to the county or the city and have the assessment lien adopted. An alternative way is the district adopts an assessment lien at the front end immediately after establishing the assessment area, from which they estimate the construction costs. Of course, the estimation can be modified when the final assessment lien is imposed, and they immediately impose the lien against the property and begin collecting on some of those costs, while at the same time using interim warrants and bond anticipation notes to cover those costs until the lien is imposed. Both that and the last option, which is you complete the construction and you pass an assessment lien, require ordinarily a board of equalization or an independent body to evaluate the estimated cost, the actual cost, to be sure that there is fair allocation on a proportionate basis across the board to those owners benefited by the improvements. And I would emphasize the issue of benefited by the improvements, because what we're seeing now with the downfall in the market is many property owners walking in and fighting against the district and against the bondholders indirectly by suggesting that because the value of the property is less than even the assessment lien, the property really has not benefited at all from the construction of those improvements. Benefit is broadly defined by the United States Supreme Court to mean basically any benefit, as long as it benefits the property to some extent. It doesn't have to be a significant monetary benefit, and that's an important distinction, because without, if you're looking at it purely from a valuation standpoint, these property owners may have a strong defense against the district. As I mentioned, there are various ways of allocation of those costs, and I think it's important that look at it from how you allocate it out and how those numbers are arrived at. As I mentioned before, the working with the property owners is essential. But one hurdle that comes up, and if you maybe allude to this, is a situation where the district doesn't establishes, for example, that the assessment lien is going to be assessed on an equivalent residential unit, or an ERU. What is the definition of an ERU, first of all? But secondly, what happens when a district is created with, say, 10 or 15 property owners, but none of those properties have been subdivided into specific ERUs, but are just basic vacant lots, if you will. They're sheepland, as they call them here in Utah. And only is there an expectation by those property owners to develop subdivisions from which the ERUs will be allocated. You might have that circumstance, but what happens then when the property owners fail to subdivide, but loan or extend credit or borrow money to do improvements, but don't have subdivisions, and you have a bunch of lenders with meets and bounds descriptions? That creates its own problems that you might face. Anybody have any thoughts on that?
We were faced with that in representing a very large hedge fund in the Northeast in the innovation of the community development districts in West Florida on that. And and these ERUs are described usually in an exhibit. I don't know why exhibit always pops into my head on this thing, but to the OS, where the way the allocation of the assessment lien is made as the property is broken down. Then in the default situation where the part of the development is subdivided and large tracts are not. And then there's some language in the Fiddler's Creek bankruptcy court decision in the fall of 11 that Vince had been looking at earlier that indicates that a court will not rewrite the allocation formula, so that the allocation formula just sits until some new money that comes in. And so he's saying that the deal will not be rewritten, so that whatever allocation report has been done and represented to the bondholders will still be followed, even though there may be a large time span when there is no activity.
Okay. In addition to evaluating these bonds and or the district's ordinances, one of the things that's important to evaluate, and it'll come up at the end of our discussion when we talk about bankruptcy and just workout issues, is the methods of payment. The reason that that's important is, as Vince alluded to, is that this is a different animal, and when it comes to bankruptcy issues, the bond was really, whether they have a claim in bankruptcy or can even defend against it, becomes an issue. The district certainly, or the county who's seeking to enforce, may have standing to pursue and be as a creditor. but the way that there's been allocation and the way that there's a method of payment, you have to evaluate whether or not, for example, you have the foreclosure right. What is that foreclosure right? Do you get to accelerate the full amount of the debt obligation and the bond obligation, or do you have to fork on the installment amount? The other thing that comes into play a little bit here is the property tax and contribution agreements. At least here in the West, we've seen is a developer will come in and instead of creating an assessment lien, will ask the community, the district, to impose a tax liability, but will then offer to contribute a proportionate amount of money to cover the tax in order to keep the tax base lower for the property owners. Sounds good in practice. That sounds good in theory, but not very good in practice if, in fact, the developer, which is occurring regularly across the country, go bankrupt. Those contribution agreements become rejected as executory contracts in bankruptcy, and suddenly the district or the county no longer has a contractual right to pursue and seek collection from the debtor developer because the contribution has been rejected.
Mark, let me just point out that it's not so. I mean, the county would claim arising from rejection of the agreement. It would be an unsecured claim. It would be it would get whatever distribution unsecured claims got in the bankruptcy, which would no doubt be little or nothing. Not as though the claim goes away per se. As a legal matter, I agree with you. As a practical matter, it would eliminate the developer as a source of property tax support.
And that's, I flip to the next slide because I want that raises the issue of the line assessment bonds are limited obligations of district, and maybe you can elaborate a little bit more, Vince, on that issue because it becomes a very significant issue as we work out the default and we deal with the bankruptcy issues that arise.
Well, and again, this is just a bit of a preview because we'll get to this specifically, but assessment obligations are limited obligations of the district insofar as the only recourse is against special assessments or if there is tax increment components to them. Sometimes there are. I mean, sometimes these bonds, as I think pointed out, they have various potential revenue streams. There is the special assessment revenue stream. Sometimes it is coupled with sales tax increment revenue stream. Sometimes it's also coupled with an ad valorem increment revenue stream. But in any event, the revenue streams associated with the assessment bonds are recourse against the district, who is bondholders obligor, limited to those revenue streams. There's other collateral associated with the bond, not as though they're general obligation bonds of a state or of a municipality. They're limited to the revenue stream associated with the special assessment and any related taxes. The other point, again, to keep in mind is that there is no claim held by bondholders against the other. And there is no lien in favor of bondholders on the project. And this has, as we previously discussed, meaningful implications in the enforcement context outside of bankruptcy, and can have some very unfortunate impacts in bankruptcy, which we can talk about later. But a quick preview, the principal impact is the holder of a claim to bankruptcy is the entity that's allowed to vote that claim for or against the plan of reorganization, is allowed to object to a plan based upon proposed treatment of the claim, is allowed to seek or not seek stay relief, And for all of those things, the ability to act is not resident in the bondholders or in the indentured trustee on behalf of the bondholders. It's resident in the district. And depending upon what contractual arrangements may exist between the bondholders and the district, the debtor may not be able to act in a way that is entirely independent of what the bondholders want.
Likewise, you have property owners who are only obligated to the district, but their only obligation is to pay their proportionate share allocated against the property, and it's really the property owner at the time that the obligation is due, and the obligation runs with the land. But if a property owner, for example, sells, you have no recourse against the former owner. You only have recourse against the property owner, and that recourse is really limited to the property that's there that's been benefited by the district. And alluded to the collateral for the assessment bonds is really a difficult thing to grapple with, because in essence there is very few, there's nothing directly collateralizing those assessment bonds other than the revenue from either the assessment lien or the tax revenue. Although we'll talk a little bit, the final bullet point there is a debt service reserve fund. It's not something that the bondholders necessarily have a right to go after, but it is a resource, as we'll talk about in terms of working out, that the district has. There is funds in the debt reserve fund to pay down on the bond. One of the issues that as you look through what's the form of the bond or form of the assessment ordinance is whether or not that debt service reserve fund has to be replenished if it's drawn against, and what that debt reserve fund has to be replenished from property owners who are paying the assessment lien or from general tax obligation by the property owners benefited by it or by taxpayers outside of the benefited area. Does anybody have any thoughts on that?
It is governed by statutory provisions. Some statutes in the East do not permit, for example, assessments to be levied to replenish a reserve fund. Normally when you get into a tax increment financing where you have tax revenues, if there are excess revenues, that often is absolutely permitted to replenish reserve funds. But normally that may not be the case with respect to assessments.
Let's turn our attention, if we can, to kind of talking about the defaults that arise and how districts and bondholders can work towards settling those pre-bankruptcy issues. As Vince has said, I mean, obviously this is a relatively new phenomenon, although it's been in place for several years as a result of the downturn, and it's being driven in large part by large property owners who hold title to a lot of property, who are unwilling to pay the assessment lien that might be imposed against their property, or the developers who have come in and thought that they were going to reap the financial reward of the upturn in the market that had been occurring for years and years, or it's simply the districts who find themselves, when the property owners and the developers are unwilling to cover their assessment liens, finding themselves without the necessary funds to cover these bonds that are in default. One of the things that as you look at outs and such, particularly with districts, is at least here in Utah, and it's true throughout the country, ordinarily districts are not allowed to file bankruptcy. So bankruptcy is not an option for the special service districts here in Utah, and so they have to find other sources of ways to solve their problems. As we look at what those issues in terms of the defaults are, is what are those preliminary issues? One, oftentimes, is the non-payment of the owner, the developer, and whether or not that owner or the developer has any interest in working with the district to try and find a solution and or pay out at some point in the future, or are they going to file bankruptcy? The experience we've had is found where the developer usually waits until a foreclosure is imminent. Only when that foreclosure is imminent do they either seek redress in the district courts through a injunctive relief, or do they just simply file bankruptcy and let the bankruptcy stay play. Another issue we've alluded to a little bit is the pressure of lenders and mortgagees, and those come in when your developer has defaulted. Ordinarily, they're not only defaulting on their assessment lien obligation, but they also find themselves defaulting to their lenders and mortgagees. And what are those lenders and mortgagees doing to protect their rights? Have a variety of issues in which, lender may close. If they foreclose, the issue becomes what was their knowledge of the district, the assessment lien. Do they think it's subject to assessment lien? The answer is yes. You have some lenders who, as you'll see in this slide, deal with notice requirements. The Mennonite is a United States Supreme Court case that deals with the constitutional rights to due process, and the lender successful in getting the United States Supreme Court to set aside a tax sale because of not having note of the tax sale. Different, though, than the creation of an assessment lien, which is what the New Beria case says, and the creation of the assessment lien takes priority in that a lender due process rights have not been violated by having the assessment lien created after the fact, because their property rights have not been directly impacted by the creation of the assessment lien, and in fact have been benefited by the construction. So those are some of the issues that come up. In addition to that are issues that you have to evaluate, which is the trustee's involvement, and what that involvement is. Jeff or Joe, do you want to kind of address that a little bit?
I guess I could.
The trustee involvement.
To start, maybe Jeff, you could chime in. Has been discussed, I guess, through the presentation. When you're, looking at the security for assessment bonds, it really is the of the payment of the assessment or any other taxes that may be pledged to secure the bonds, and really looking at procedures that are not going to be implemented by the nor the trustee. It is really, looking at the city or the county that created the district that will affect the collection of the assessment. Trustee is usually a party to whether the memorandum of understanding or a collection agreement as relates to the procedures for collection, and usually that agreement is assigned to him, and he has rights to pursue against the city or the county if they're not, proceeding with the action of the assessment in accordance with the agreement. But as I indicated earlier, there's a lot of discretion on the part of the city and the county statutorily. If you look at the face of the indenture, all of them, they may be different, but I think generally speaking, indentures do not provide much in the way of remedies to the trustee in connection with the ability to do any rights against any of the other parties. As we talked about, there's a non-recourse obligation to the property owner. They may have some rights against the district if the district isn't performing under the provisions of the indenture. But again, these are very limited types of rights and obligations. That the trustee may have. I think the role of the trustee really becomes greater in connection with the facilitation of a restructuring of the bonds, working with the bondholders, with the district, if there are other lenders, in trying to, again, facilitate a restructuring effort if if one seems to make sense given the factual situation. And this is an instance in a existing transaction in Virginia where, at the direction of the holders, the trustee, and with indemnification, the trustee is being asked to file a complaint against the city in this particular instance due to their collection procedures and in our mind the failure to comply with agreements that they have entered into.
And I'm assuming that that's to get the district to act, as opposed to just sitting on their hands, if you will, and not doing anything because of the non-recourse nature of the obligation to the bondholder.
And, there was a question that came in that sort of sparked some in here. The front end of the deal in the CD situation, I assume that's what the question relates to. Can the assessment be something greater than the amount due to the bondholder? And I've never seen a deal that would assess the land not only for the future value of the payments plus interest, but also for a cushion.
Typically, the assessment will be set to pay the full amount of the debt service on the bonds, pay administrative expenses,
right,
and in jurisdictions where you can use assessments to replenish, there be a in effect cushion, as you talk about, where they want to achieve 110% coverage on the bonds. But there obviously each parcel will be subject to a maximum tax. But the components that I've seen over and above the actual payment of the debt service is to pay administrative expenses, to perhaps replenish the reserve and create a little bit of a cushion. Because as we know, failure of one property owner to pay assessment on their property is not going to be an obligation of one of the other property owners as it relates to its property.
Right. But we're not going to. I have not seen any deal where there's this extraordinary cushion created by the assessment. I think it's saying, Joe, right? Yeah. So
that's true, and I think as a practical matter, given the fact that the projects that are being financed here are residential developments, the developer could never, a property owner is never going to buy that piece of property if it's going to be subjected to a significant assessment.
Well, that raises another good point, Joe, and if you might want to capitalize. The one thing that with all these is important in the impact that any district has is what is its impact on not only the property values within the district or the assessment area, but what impact does it have within the general county as a whole. What we're experiencing, at least here in Utah, is from an initial standpoint, to 3, 4, 5, 6, 7 times the value of the property. The value of the property was 7, 8, 9 times the value of the assessment lien. What we're finding is that the prices have so tanked as a result of some developments here in Utah that the assessment lien exceeds the value of all of the property combined. Mm-hmm. And so that impact, and when you're looking at that impact, you have to look when you're talking about restructuring and or working things out, how long-term do you see? Because property owners are going to be unwilling to expend any time or resources to clearing the lien if, in fact, the property values are so much depreciated at that point.
Yeah, I think that's a judgment factor and an evaluation that has to be made. Typically, I think the rule of thumb in doing a brand new financing is that you want at least, a 3-to-1 value to lien, that the property value is at least 3 times the value of the lien of the assessment. And I think that's really tying into likelihood that a property owner will continue to pay assessment given the value of his property. And as you point out, once you get to a situation where the property may have less value than the assessment lien, then why would they continue to make that payment? That is, I think that's the analysis.
Well, and you talked about us, the trustee, somewhat being a facilitator between the holders and the district. I suppose they also act as a facilitator between the district and the property owner in assuring that the district exercises its rights sufficiently to ensure that the property owners are held to the fire and pay their fair share of what they need to pay. And I'll make one additional comment as to what Jeff was saying in terms of what assessment can basically build a cushion. Here in Utah and in the neighboring states that we deal with most of those public financing situations is there's an estimate. That estimate takes into consideration all of the, if you will, holding costs, management costs, if you will, soft costs that are built into that so that the property owners know going in precisely what their obligation is. End of the day, we would hope cannot, to avoid the liability by adjusting that they're uninformed as to what those costs were, or that their property is being unlawfully taken because you're imposing such an obligation on a property, which then turns you to other issues that we face in evaluating how we can work things out and restructure this, which is, what are the limitations of the assessment ordinance? And both Jeff, I think, and Vince, you talked about Fiddler's Creek, the language there, and what are the limitations in amending an assessment ordinance to deal with these now defunct developments and districts?
Well, the Fiddler's Creek, just for people who may not have heard of that case or decision, in Florida, you had a bankruptcy of the developer that owned land upon which the assessment lien was placed, or had been placed. And bankruptcy plan depends that the landlord would make, and of course he was the most significant landowner, would make to the district actually a 2-year moratorium, and there was some negative amortization, as I recall. And otherwise, what happened was the owner's obligation that would otherwise be imposed by state or otherwise applicable non-bankruptcy law is modified through the plan. The bondholder says, well, wait a minute, it's going to interfere with our payment schedule, and we're not able to get paid according to our bond terms, and go into the bankruptcy court and object to the plan, and otherwise have some influence in the renovation plan. And the bankruptcy court rejected essentially their standing, and said your claim is only against the district, which is not in bankruptcy. The only bankruptcy was a Chapter 11 bankruptcy of a private entity, and you just made a bad deal, and don't come to the bankruptcy court and ask us to rewrite that deal. So when you do a restructuring, you're looking at, or should look at it from the world's eye view of the developer or landowner. It's where most of the development has not been subdivided and sold to the retail public. In that situation, you're dealing with I hate to use the word garden variety, but you're dealing with Section 129B cram down kinds of issues. Is the lien, the value of the lien, or the present value of the lien, really being given through some consideration back to the district? And the bondholders are really left holding the bag in that situation. But as Vince mentioned earlier, there is no direct line from the bond to land. And I digress from that point for just a second, because I'm faced with it. I don't really have an answer for it. I'd like to get the panel's view on. If you have a tax sale, and this is what they call hard break, right? But if you do a tax sale and the district does decide to enforce the lien, tax lien, the bondholder essentially go in with this bond, I have the term credit bid is right. But take the bond and say, listen, I got a $10,000 bond. I want you to carry my bond on the land at the tax sale.
I think the answer to that is certainly no. And because...
And that's a big deal, because a lot of bondholders have asked me that question.
Mm-hmm. Yeah, you really have to look at state law questions. I mean, anywhere I've looked at it, credit being is not permitted.
The other thing, and Mark, I think this goes to your point on the issue of the assessments. Typically, at the beginning of these projects, there is sort of an allocation plan that's part of the OS that an expert is brought in to sort of allocate the special assessment across different properties. And that allocation may or may not prove with the advanced time to have been appropriate. Depending on what happens to various property values and the like. One of the complaints in Fiddler's Creek by the indenture trustee, bondholders, was that the initial allocation plan had not worked, or had not worked, or had been deliberately ignored, and that there were certain properties that were overburdened, and certain properties that were underburdened. And bankruptcy court, consistent with some of the other holdings it made in the case, essentially said, you know what, that isn't my problem. I'm going to research your you made it based on a particular allocation scheme. You're going to have to live that allocation scheme. In fact, I'll give you the exact quote out of from the judge. I find these debtors have no obligation, legally or economically, to enhance the rights or collateral of the bondholder. So,
so that then raised the question, and I'm going to throw it up because it's here in this slide, and it kind of goes the rest of the slides up to bankruptcy. Is what is then, if that's the case, Vince? What is then the ability of the districts and the bondholders to restructure and or to negotiate and work out assessment ordinances that are in some respects in zone to ensure that they get paid ultimately to protect the value of the community and the property owners, and to ensure that districts meet their obligation to both bondholders and the property owners, and making sure that the projects are complete. I mean, that's a general, large question, and the participants will provide them with the slideshow, but the next several slides deal with other options. But what is the ability of the district to negotiate new terms, and or the willingness of bondholders to negotiate new terms?
Yeah, my experience has been, I mean, normally, and I think you have to make certain assumptions. I guess maybe the first is that the project still has viability, that you're not looking at a situation where there's no way that this thing can be turned around. So let's just assume that situation. And that the real issue is, through the economic downturn, everyone concludes that there is still viability to the project, and it's just a question of timing and the ability, giving more time to the developer to implement his plan, or perhaps in agreement with all the parties to conclude that maybe you need to make some modifications to that development plan in order to market demands at the particular time. But oftentimes the developer will take initiative and submit a proposal to the district, to the trustee, who would involve the holders of the bonds. And there's kind of evaluation by all of those parties. And if is a developer will come in and basically set out his revised plan and timing for implementation of it. And if it make, an additional 2 years, maybe 3 years, let's get, debt service reserve fund monies to fund some additional capitalized interest, and as a result, some of the assessment payments that are coming due in those early years, the principal, maturity on the bonds, those are all of the kind of approaches that are being taken, but
all of that,
yeah.
Joe, though,